Okay, so we are here today with an update on a landmark Supreme Court case the National Foundation for Gun Rights is involved in. And joining us today to tell us about it is our chairman of the board, Dave Warrington. Dave is a constitutional attorney and is heavily involved in litigation involving political liberty and constitutional rights. So Dave, thanks so much for sitting down with us today.
Thanks for having me, Hannah. How are you doing today?
Doing well. How are you?
Good.
Good. So first off, this is a free speech case and we are a gun organization. So why is this issue important for us to get involved in?
That's probably the most common question we get when we undertake these kinds of cases. But it's often said that the Second Amendment protects all the other rights. But that actually can be said of each of the amendments to the Constitution, each of the Bill of Rights. They all have an interplay where they protect each other. And the First Amendment protects essentially 5 core freedoms: religion, speech, assembly, the right to petition your government for redresses, and even protects the right of the press. And for a gun rights group, we certainly have at least 3 of those in play in any time we're dealing with the First Amendment. Because as an organization like the National Association for Gun Rights, we have members who have come together, they've assembled because they believe strongly in the Second Amendment freedoms. They join together so that their voices can be heard, that they can petition their government for redress of grievances. They can talk to other people to try to convince them of their positions on the Second Amendment. These are core First Amendment freedoms that, frankly, the more you chip away at them, the easier it is to chip away at the Second Amendment freedoms. So that's why it's important for gun owners to keep an eye on these First Amendment cases. Also, Fifth Amendment cases, Fourth Amendment cases. As I said, there's an interplay between the Bill of Rights and the other amendments to the Constitution that they protect one another. And we have to keep an eye on that. Even though we are a Second Amendment organization, there are other cases that involve the First Amendment or the Fourth Amendment that would weigh heavily on our rights as Americans to freely keep and bear arms.
Right. So can you give us an overview of this particular case and kind of its history and how it got started?
Sure. This case goes back to a change in California law in about 2010. Well, actually, it wasn't a change in law. It was a change in how the California Attorney General, who at the time was Kamala Harris, that name should sound familiar to everybody. When Mrs. Harris was the Attorney General of California, she wanted to increase the regulation on organized groups that participated in political activity and political speech. About 41 of the 50 states have what are called charity registration laws, which means if you are an IRS designated 501c3 organization or 501c4 organization, such as the National Association for Gun Rights or the National Foundation for Gun Rights, in order to communicate with your members and to ask them to participate in the organization, to support the organization, support the mission of the organization, contribute money to the organization. In order to do all of these things, you have to register with each of these 41 states, California being one of those 41. And as part of that registration process, you have to provide them with your tax documents, your tax return. As a nonprofit organization, you file what's called a 990. You and I, we file an IRS 1040. But for a nonprofit organization, the form is called a 990. So that's the shorthand that everybody uses. Part of that 990 is what's called Schedule B. Schedule B is a list of donors to the organization. Well, prior to 2010, in California, you would file what was called the public Schedule B, which is a blank form. You file the Schedule B with the IRS and disclose that information to the IRS, but that information is protected by the IRS. Now, I'll be candid with you, a number of groups do not even file that information with the IRS. They file a blank 990 Schedule B in order to protect their donor's identity. And that's going back through some case law from a couple of cases back in the late 70s, early 80s. Goes all the way back to a case in 1958 called NAACP versus Alabama, where, as you can imagine, the atmosphere in Alabama in 1958, there were people agitating for civil rights, and the sheriffs in Alabama decided they wanted to get the membership list of the NAACP to find out who these agitators were. And the Supreme Court says, no, you can't do that. You have a First Amendment right to assemble, join in a group, support groups that you support and their mission support, and you don't have to. There's no requirement that it be publicly disclosed or you have to file anything with the government. And that principle has been carried through, and organizations have stood on that principle. And it's a very good principle, particularly in light of what we're seeing today. If you're found out to support any controversial cause, you can be attacked. Your home can be people can come to visit your home, protest outside your home. You can be doxxed, and all those sorts of things. Well, this case, what happened in 2010, Attorney General Harris decided that she was going to require any nonprofit groups, particularly conservative nonprofit groups, no surprise there, to have to file their 990 Schedule Bs with donor information. The plaintiff in this case was the Americans for Prosperity Foundation. They sued on behalf of themselves and said, hey, we shouldn't have to do that because we are open to ridicule, scorn, retaliation, and all of that stuff. And based on the principle that was enunciated in NAACP versus Alabama in 1958, the state is not entitled to this information. So that was the basic beginnings of the case. Now, why it's important to us? Well, the National Association for Gun Rights and the National Foundation for Gun Rights has also been asked to file our 990s in California. And we have so far refused to do that. And things are stayed because of this case. So it's important how this case comes out because at that point, if it comes out wrongly, then you can imagine California is not necessarily a great state for the Second Amendment. They're going to be pushing against pro-Second Amendment groups to try to get their members lists, and those things mysteriously become public and put those folks, our supporters, in harm's way. So that's why that case is important. It started in 2010. It went up to the Ninth Circuit. The Ninth Circuit said California has a right to this information. They can do this. The plaintiffs appealed that to the Supreme Court. In the process, what is known as petitioning for a writ of certiorari. That writ was granted. A writ is basically a permission asking the court to hear your case. That writ was granted. We filed an amicus brief, which is what an amicus brief is, a friend of the court brief, which essentially is someone who's not a party to the case. Says, hey, court, we have an interesting perspective on this that you should know about. And we have a particular interest in this case that our rights would be affected as well. And that's the basis for the amicus filing that we made. Right.
And can you give us kind of an overview of what we're saying in our amicus, what the arguments we're making before the Supreme Court are?
Sure. And that's one of the great things about this. And I'm particularly excited about the arguments that we've made. Whereas the plaintiff is really fighting for their particular situation. We've taken a broader perspective and said that these charity registration laws, not just in California, but across the country, are effectively a license on speech and a prior restraint. And there's a prohibition in the law on prior restraints on speech. And what a prior restraint is exactly what it sounds like. I tell you, Hannah, that I know you're going to say something. I tell you, you can't say it, or you have to pay me a license in order to say it. That's a prior restraint. And the argument that we're making is essentially that California has this process along with these other states, which effectively require us to register to communicate with our members and supporters. And that's a prior restraint on our First Amendment freedoms.
So what's next with this case?
Well, what's next is oral argument. All the briefings completed. The case is set for oral argument on April 26th, so that's just over a month away. Once the oral argument is completed, the judges will assemble and make their decision on how they're going to vote and issue their opinion. So we can look for something probably in the summer, hopefully, toward the end of the term, and we'll know where this goes from there. It's a pretty exciting case if it comes out our way, because it will not only protect the First Amendment rights of member organizations such as the National Association for Gun Rights and the National Foundation for Gun Rights, but it will also consequently help supporters of the Second Amendment from protecting their identities from being disclosed through these charity registration regimes.
Good deal. Awesome. So, in a nutshell, if you had to say, what's at stake for gun owners with this case?
Not to be too filled with hyperbole, but everything, frankly. If government is allowed to put these restrictions in place and have this slowly creeping extension of their intrusion into the ability of member organizations and individuals to assemble, to speak, and to challenge government regulations, if that's allowed to continue, we will slowly lose all of those freedoms that are protected by the First Amendment and the Second Amendment.
While we have you, isn't there also a key Fourth Amendment case involving gun seizure that's also before the Supreme Court?
Yes, there is. There's a case called Coniglia versus Strong. It involves a husband and wife who had a little argument, and the husband, I guess, got pretty heated, and he went back to his bedroom and picked up his empty revolver and tossed it on the counter and said, "Well, get it over with. Just shoot me right now," and then walked out of the house. Not a real wise move, but it was more hyperbole than it was anything else. The wife agreed with that. The husband agreed with that. What ended up happening is the next day when she had left the house to go spend the night at a hotel, she called the next morning to try to reach her husband to continue to work things out or continue to fight. I don't know which. But he was out on the back porch, didn't hear the phone ring, so she called the cops. The police went over there, talked to him. He was not agitated. He just said, "Look, I'm sorry, I shouldn't have done that. I was sick and tired of fighting with my wife, and so I just, it was a dumb move." He admitted the cops didn't think he was anything in particular showing any signs of aggression, anything like that, but they decided to take him into custody anyway. And when they took him into custody, they started searching the house. They took the gun, and he said they had told him, "Look, if you go with us, we'll take you to the hospital, get you sort of assessed for mental health. If you go with us, we won't take your gun. We won't do anything else. We want to make sure you're okay." So he said, okay. The wife agreed with it. They were all in compliance with the police officers. Well, the police went back to the house. They picked up the revolver that he had tossed in his little episode, and then they continued to search the house, and they found another handgun.
After they told him that they would not.
After they told him they would not. And they didn't have permission to do this. Neither the husband nor the wife gave them permission to go back into the house and take the firearms. They did this, and then when he gets out of the hospital, they find out that the guns are missing. They call the cops and say, we want them back, and the police say no, and then they had to sue in order to get them back. They ultimately got them back, but the question in the case is, and what they sued for was, there was no warrant in this case. There was no magistrate finding that he was a danger to himself or to his wife or to the community. There were no other exigent circumstances that would have allowed them to go into the house and conduct a search without a warrant. Now, what the police argued was that under their what's called the community caretaking doctrine, which is an exception to the Fourth Amendment, they were trying to protect the community from a dangerous individual. There was no evidence that he was dangerous. There was no finding that he was dangerous. There was, again, like I said, there was no warrant. There was no magistrate's order. Police just did this on their own. The Ninth Circuit said, well, that's okay. They could do that under the community caretaking doctrine based on a case that goes back to 1973 called Katie, which involved a police officer who had gotten into an accident, and the police on the scene, he fled the accident scene. The police that showed up to the scene went and got the guy, got the police officer, realized he was drunk. They arrested him. They searched his car for his revolver just to make sure that the revolver didn't fall into the tow truck company's hands or some other person's hands that shouldn't have had it.
Right.
In the course of that search, they opened the trunk and they found evidence that this police officer, who was a drunk police officer who was in the accident, had actually been involved in a murder. And the Supreme Court in Katie said, well, they had a legitimate reason to search the vehicle in order to prevent his service revolver from falling into the wrong hands. That's only been applied to outside of the home.
Mm-hmm.
Whereas in Mr. Coniglia's case, we're talking about the home. The home has always been sacrosanct. You need a warrant to come into someone's home, unless the house is on fire and you're trying to get somebody out, or some other exigent circumstance that weren't present here. Under the Ninth Circuit ruling, it would expand the Katie ruling to cover the home, and that's the issue in the case. Does the community caretaker exception get expanded to cover the home? And the Coniglias have said no, it shouldn't. And that's why that's important, because as we know, under red flag laws and all the other sort of recent attempts to try to give police more power to seize firearms, this is a very slippery slope, because the facts of the case show that there were no exigent circumstances. Mr. Coniglia was not a danger to himself, danger to his community. Yes, he did and said a stupid thing.
Right.
At least at this point so far in this country, you're allowed to say and do some stupid things so long as you don't harm yourself or other people.
Right. So a lot at stake for gun owners with both of these cases then. What can concerned gun owners do to get involved in all of this?
Well, they've got to remain vigilant, and how they can do that is they can join the National Association for Gun Rights, the National Foundation for Gun Rights, join with other Second Amendment supporters, keep abreast of these issues. We send out a lot of information trying to keep our members and supporters up to date on what's going on, the various challenges and battles and opportunities that we have. So I would encourage everybody to join our organization, to support our mission, and keep an eye out on what politicians are doing, and don't be afraid to speak out.
Well, Dave, that was incredibly informative. We really appreciate your taking the time to sit down with us and for sharing your expertise.
Thank you, Hannah. Have a great day.
And you as well. For more updates on these Supreme Court cases, or to make a tax-deductible contribution to help us fight for the Second Amendment in the courts, you can go to our website at gunrightsfoundation.org. And if you want to stay up to date on gun control and the Second Amendment, please click the like button and subscribe to our channel. Thank you for watching.